Staff will present the site plans, maps, photographs, and other documents that comprise the case record. At the conclusion of the staff presentation, the appellant will present his or her case to the board. After the appellant's presentation, the board will hear those wishing to speak in support of the appeal. If the appeal has opposition, the board will then hear from the opposition, and the appellant will have a period for rebuttal. According to the BZA rules, the appellant has 5 minutes for presentation if no opposition is present. In contested cases, the BZA rules allow for 10 minutes for each side. Should the appellant wish to provide rebuttal testimony, you would want to reserve some portion of your allotted 10 minutes in order to make that rebuttal. At the conclusion of each hearing, the board will deliberate and then vote on that case. The board is vested with the power to act on these cases under the provisions of the Metro Zoning Code, Section 1740-180. All section numbers that we refer to come from the Metro Zoning Code, which applies to the entire jurisdiction of the metropolitan government. The Zoning Code was adopted by the Metro Council and became effective on January 1st, 1998. I will introduce the entire Zoning Code and make it a part of today's record. The Metro Code requires a record of these proceedings. Because BZA meetings are recorded for Metro Nashville Network, it's imperative that anyone addressing the board come forward and speak into the microphone and identify yourself by name and address for the board. Then you may make your desired presentation. The Metro Code requires 4 members of our 7-member board to establish a quorum. The code also requires at least 4 affirmative votes to grant an appeal. In the event that 5 or more members are present, if the appeal fails to receive 4 affirmative votes, the case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within 30 days of the public hearing will be deemed denied by operation of law. Pursuant to board rules, an aggrieved party may appeal board decisions to Chancery or Circuit Court within 60 days of the hearing date. Additionally, as per the BZA rules, an aggrieved party may file a motion for rehearing by the BZA, also within 60 days of the original hearing date. After that time lapses, the board's decision becomes final and no further action can be taken. If your appeal is granted, you are required to obtain the permit for which you applied. A permit must be obtained within 2 years for a board approval to remain valid. Given that all of these are short-term rentals, that obviously would need to be done before the expiration in the event your permit is reinstated. It should also be noted that if false or misleading testimony is presented to the board, any board approval could be revoked at a later date by means of a show cause order, or a show cause hearing rather, before the BZA. Mr. Chairman, I submit that all cases have been filed in proper order, all appellants have been notified by certified mail, and all legal notice requirements have been fulfilled. Seeing no council members here to address the board, I believe we're ready to proceed with the meeting today.
Great. And before we start, I would, Emily, if you could please tell us, each of the cases that we have today are exactly the same in nature in terms of why they're here, and they also are the same type of case that is being heard in Chancery Court. And can you tell us just the nature of what these cases are and where things stand with proceedings that maybe are outside of our body?
Certainly. So, as you know, this is a specially set meeting set specifically for these cases because they do all involve the exact same fact pattern. Essentially, under the current iteration of the short-term rental law, which was passed in February of 2018, the night of the 3rd and final reading, there were a flurry of amendments that were introduced on the council floor. Some of those amendments passed, some of those amendments did not pass, and quite frankly, codes just missed this particular amendment that did pass. There was an amendment. Amendment 9 is the amendment number, I think out of 16 that night. And it's 1716-250 F1, I believe, was where it was codified. And that amendment passed, and it stated that in single and 2-family zoned districts, first of all, you can only issue 1 permit per lot. And second of all, in 2-family, when there are 2 units, both units must be owned by the same person, and the person must live in one of the units. And again, quite frankly, among all the flurry of amendments and changes, codes just missed this particular amendment. So we continue to issue permits on properties that had 2 units, that were two-family dwellings. We continue to issue permits when there were 2 dwellings, even if they weren't owned by the same person. Once we realized our mistake, we revoked the permits. There were 144 total. Of those 144, 44, maybe 45 property owners sued the city in Chancery Court. Those are the cases that are pending in Chancery Court. In those lawsuits, Metro Legal agreed to enter a temporary injunction that prohibits Metro from enforcing the short-term rental against this property and treats those permits as still valid, as if we had not revoked them. So that's the current status of those, and that's a temporary injunction until the court has had an opportunity to hear the case and rule on its merits, at which point the court will give us direction how to treat those permits in this issue in general. So those particular cases that are in court have injunctions on them temporary until the court can rule. 9 total of these cases appeal to the BZA. And so you're here today.
So 145, 44 went to court, 9 have come to us. And I think we've heard some before. Is that not right?
Not this issue. This
Okay.
issue, expecting, frankly, that more people would appeal.
Oh no, we've had people appeal the ability to get a permit, but not one that was denied, right?
We've had some people who have appealed the denial of a permit or a revocation or cancellation of a permit, but not for this exact issue being 2 units. We issued it in error because they were 2 different owners.
Issued in error, right?
That's right.
Okay. Right. I just thought at some point in time we had talked about the zoning administrator's interpretation of this amendment and had agreed with the zoning administrator that it was very clear that the rule is.
Yes, okay, I'm sorry, I followed you. Yes, we have heard cases where after we realized that we had been issuing an error, determined that the law did in fact prohibit those permit issuance in those properties, we then rightfully denied permits under those circumstances. Those people have appealed and have come to you and I believe that you were correct. I believe you determined that we did not err in denying those.
Okay. Yeah, I believe that's, I do remember it because from my recollection of that amendment, it is fairly clear. There wasn't a lot of gray area. Did you have more to add on that? So I guess I want to, before we start, I want to talk with the board about this because we have a situation where 144 permits were issued in error, according to the Codes Department, and they were revoked. 44 have gone to court. 9 are in process, 7 today, and 2 on future agendas to be heard here. And in my mind, the way the court has ruled is that the temporary injunction that basically says the property owner should be able to continue doing what they're doing until the court rules is, to me, would be a fair solution to these cases too, because I think it would be advantageous not only to the appellants, but I think it would be advantageous to the city because it would presumably let them have relief without having to file a lawsuit. And then once the court case is resolved, however it's resolved, I mean, the court may come in favor of the Metro and the zoning administrator's interpretation of the law, which this board has also acted on, in which case these applicants would not be able to have a permit. But if the court may decide otherwise for whatever reason the lawsuit is, and if the court does that, then they would be eligible to have a permit and they should keep going. So does the issue make sense to everybody? Everybody understands what's happening? Because it took me a minute, again, when I was reviewing the agenda and again, talking about consent items, if any, and that type of thing, and said, hey, help me really understand this. It took me a minute. I want to make sure the board understands it because, or has any questions, and if not, I'll make a motion and then we can discuss it further, but I want to make sure everybody understands the issue at hand. So with that said, I'm going to move that we defer these cases indefinitely with the following conditions and comments. One is the Chancery Court now has dozens of cases with exactly the same facts as the ones that are being presented today. And in those cases, the parties, the applicants, and the city had agreed to a temporary injunction, which means that the short-term rental operators would be allowed to continue operating until the courts resolve the cases. The motion here is that we would handle these in an identical manner, the identical cases in the same manner. So the appellants today would be allowed to continue operating until the courts resolve the cases now in litigation. And once the court has ruled on these cases, the applicants are going to be notified of their status, and the status will either be a new BZA hearing date, which means that the court did not rule in their the applicant's favor, or the BZA would adopt the order of the court, which means that they would just be allowed to continue operating as they always have. So in short, we're going to let the court decide the issue and then address these cases at that time. In the meantime, the motion is that they would be allowed to continue with a valid permit.
So for clarification, when you say until the court resolves this, you mean until the Chancery Court issues a ruling? Okay.
Until the Chancery Court issues a ruling.
Okay.
Well, I guess I have a question. If they did not join with, and I don't know if it was what kind of lawsuit that 44 engaged in, if they did not join in that lawsuit, how can we say this legally affects them?
Well, to me, it's what is the fair solution that benefits the city and the applicant, and and I think, well, if I were told no today, I would go join the lawsuit, in which case I would get the same injunction, and that's not advantageous to the city because it just means more people are in a lawsuit. And how can we provide the same relief and know that there's also 100 other, 90 others out there that may want to be in the same situation? And it's, is there a way to basically not penalize the applicant, or the city, and to say it's currently being decided by a court that has greater authority than this body, and let's wait until that happens. In the meantime, keep doing what you're doing.
Well, as I said, I don't know if it's a class action suit or what it is, but I guess I would want our lawyers to answer if it's possible for them to join that later after it's already been filed.
I can answer that. It's not a class action lawsuit. It's 45 individual lawsuits that all filed 45 individual requests for TROs, which is how we got into the situation of Metro Legal agreeing to the injunctions. So if you defer them today, as Mr. Chairman said, they would be deferred. We would not, we would treat, if you are mirroring the court's action, we would treat these permits as valid until the court rules on the issue at hand, which is whether or not this amendment or these permits at issue should have been revoked or if they should remain valid. If a person wanted to appeal this decision, if y'all don't defer it and you take an action either to uphold the zoning administrator or overturn the zoning administrator, the appellants could appeal those to the court. If they wanted to go the route of filing a new lawsuit from scratch, that is what has been done on the 44 cases. But either way, it's not a class action. It's 45 separate TROs.
And so, I mean, that again, just thinking through what is, in my mind, what's a fair solution to the applicant, but yet protects the city and is respectful of the law that was passed, but knowing that that the court has viewed it and as such that because it's an open question that the applicant should be able to continue until that question is solved. And again, I'll let the lawyers figure out whether it's messy or not messy, but it comes from a sense of, well, what's the fairest solution to all parties involved, the applicant and the city, maybe in the other order, the city and then the applicant, not putting one ahead of the other. But it just seemed like as we're going to get more of these, that it would ultimately make for the best solution, and I think we will get more. So yeah, I did make a motion. There's not a second.
I will, as the other non-attorney on this board, I will second your motion.
Okay, so there is a motion and a second, and so we can have more discussion on it. And the only other thought is after, maybe it's after we vote on this motion, is as new cases come, do we want those to be kind of on a consent type agenda that we defer at the beginning of the meeting, or is that something that we want to talk about, maybe even doing administratively? I think it's probably cleaner to vote on it, but depending upon how many there are and just kind of that sense of equity, we may want to talk about that. But is there any other thoughts on how to solve this or this specific motion, or amendments or other criteria?
What do you think we should vote on?
Well, it's a discussion, a motion, a second, and then this is a chance to either clean it up or say it's a good idea or it's not a good idea at all, or whatever you think about the motion.
I think it's not, not only is it a reasonable alternative, it's really the only alternative, because other people, if we uphold the zoning administrator and they go join the lawsuit, they're going to get the stay anyway. They're going to get the same injunction. And so we're just making people jump through hoops. It doesn't seem like serves any real purpose.
Right.
So I don't.
Well, that's right. It felt like it would be expensive for the applicant and the city to go another route. And that was part of, when I talk about fairness, that's part of that too, is it would take city manpower and applicant manpower and financial costs that could be avoided. So that was the goal.
That's answered my question.
Okay. So,
Me too, and I think what's good about your motion is that also then it'll give us a framework for consistency.
Right.
And so then we'll have some guidance on how to decide these. So
right.
that's pretty much.
Thank you. And that was part of the goal too. So, okay. So with that said, all in favor of the motion, say aye. Aye. Any opposed? No, that motion passes. So each of you here today, I think that you all understood what we were talking about. So these are deferred indefinitely until the court cases are decided, and your permits will be, do they get reissued or do they just?
We will treat them the way we've treated the ones in environmental court, Chancery Court, which is that we will treat them as valid. They can continue to operate. Upon the expiration, they will need to renew them. We'll renew them and treat them as renewable, which is, again, also how we've handled the ones that are in the court cases have been handled. So we're basically treating them as valid, and upon expiration, we're renewing them unless and until the court directs us otherwise. Okay.
And the only other outstanding question is just to get at, and again, open it to the board to ask you what their, again, 44 cases that are being handled in court, 7 we handled today. That's 51. There were 144. So whatever 144 minus 51 is, thank you, is how many that we have. And so I don't know what those applicants or those people that were denied or had their permits canceled are going to do. But the question is, do you want to handle those in the same way where they file an appeal and we make a motion like we did today, or we could make a motion that for those 93 cases, if they appeal, we could offer them the deferral under this same condition with the approval of, it would be me because I'm the chair, or any member. I don't, a representative from this body and the zoning administrator. And I want to ask our legal counsel, we don't have our legal counselor today, but we have our former legal counsel.
I think that the board has the discretion to direct staff how to act with respect to particular cases. It might be cleaner to take the cases and let them come before the board, potentially as a consent agenda item. But if the board determines otherwise, that y'all would rather us handle it administratively, I do think that it's something you could probably direct us to do, and we would act accordingly.
I mean, the thing about the administrative solution here is that we know who these cases are. They're known, and we know why, and so it's not. That's the only reason I think. Well, maybe it would make sense, and that way, when someone comes in to to appeal. They know how to handle it. So, I mean, that's just where I thought it might save them some time and us some time. But again, it's totally up to you all, and
I would point out that if they do come in to file an appeal, there would be a case number assigned to it. So if it came before the board on a consent agenda, there would be an order that we could then attach to that case.
Well, I know that we've heard many of the people who come before us say they had to take off work. It's a lot of trouble to come down here. So I think if, in the interest of saving people that effort to come here, that we should instruct the codes department to do what they need to do to allow these persons, this 93 people, if they hear from them, what we've decided.
How about maybe a hybrid, and let me ask if this makes sense. If they come to file an appeal, and they do file an appeal, which would give them a formal case number, that we would, on those 93 cases, give the staff the ability to automatically defer that case indefinitely under these terms. That way it'll have the case number.
That's what I meant.
Okay, I'm sorry.
Yeah.
It'll have the case number. They'll actually have to file an appeal, but then it is automatically deferred because we know what type of case it is. Is that?
I think that's fine.
Okay. Is that, did you want to make that motion, Alma, or did?
Yes, I would love to make that as a motion. Okay.
Well, we have a motion and we have a second. Any discussion? All in favor of that, say aye. Aye. That passes unanimously.
And one point of clarification, I guess, would that be considered a board, part of the other order, the previous order? So in these cases, we're putting it all, or I'm trying to figure out how to enter this order, basically.
Yeah, well, and yes, it is that the motion, I believe, was that they would be required to file an appeal. The appeal would be handled with the exact same conditions of the previous order.
Okay.
It would be deferred indefinitely under the exact terms of the motion that we just passed previously. And depending upon the court case, that their appeal would then be heard or not heard, depending upon the way the court rules. But it just allows you all to handle that. As soon as someone comes and appeals under this exact same situation, those 93 cases, you can say, okay, here's the deal.
Okay.
You're good to go, but until the court decides.
Got it.
Is that good? All right. Nothing else on the agenda? Any announcements? All right, we're done. Yay.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.